This series tries to dig into the intersection of estate planning law and disenfranchised and underserved communities, such as Native Americans. There are about 400 tribal justice systems in the United States. Since states do not have jurisdiction over Native American land, tribal courts are a freestanding part of the tribal government that oversees legal issues that arise. What is tribal sovereignty, and what kind of cases do tribal courts hear? Today, Judge Joseph Wiseman of San Manuel Tribal Court joins us to explain how the court operates, where the state's jurisdiction ends, the tribal law prevails, and generally, the type of issues that come before the bench. ACTEC fellow Robert Barton conducts this interview. Robbie?
Hello, everyone. My name is Robert Barton, and I'm pleased today to be joined by Judge Joseph Wiseman, the supervising judge of the San Manuel Tribal Court. And we're so pleased to be able to talk to you about trust estate issues that might be encountered by in tribal court, and to have Judge Wiseman talk about sort of the things that he sees on a day-to-day basis. So welcome, Judge Wiseman. I'd like to start by having you do a brief introduction of yourself and what it means to be a tribal judge.
Thank you, Mr. Martin, and hello, everybody. I'm Judge Joseph Wiseman. I'm the supervising judge for the San Manuel Band of Mission Indians here in Highland, California. I also serve as a chief judge for a few other tribes in California, both in Central California and in Northern California. I've been a full-time tribal court judge for about 5 years now. Before that, I was a practicing lawyer. I was a litigator. I did a lot of cases in federal court. Primarily, our practice was in federal court in my firm, but I did have experience in elder abuse cases, employment litigation cases, and sort of run-of-the-mill, if you will, civil litigation. So, as I said, I've been a judge full-time for several years now, and I see a variety of cases in not only the San Manuel Tribal Court, but the other tribal courts I work for.
Could you talk about what it means to be a tribal court as far as a unit of government and how it's structured and where you look to law and that type of thing?
Sure. Typically, tribal courts are engrafted, or the authority for the tribe to create a tribal court is usually engrafted in the tribe's constitution or other organic legislation. So, for example, some tribal courts are created by virtue of a provision in the tribe's constitution. Other tribal courts are created because the tribal council, which is usually the governing body of the tribe, authorizes the creation of a tribal court. Tribal courts are a branch of tribal government, whether they're created through an ordinance by the tribal council or whether they're created by virtue of the tribe's constitution. In my experience, the tribal courts are independent of the other branches of tribal government. And in my experience, the other branches of tribal government respects the independence of the tribal courts. Here in California, we have 109 federally recognized Indian tribes, but we have only about 35 or so tribal courts. So we're still in California, sort of a small pool of tribal judicial forums. With respect to the law that I look to, typically in first instance, I look to the law of the tribe. So most tribes have tribal ordinances, tribal codes that have been passed, and depending on how the government is structured, either it's passed by the tribal council, or in some tribes, the ultimate governing authority of the tribe rests in the membership. So sometimes a tribal law has to be passed by the membership. But I looked at tribal law. If tribal law is absent, or there is an area of law that I have to deal with that's not covered by tribal law, then I have the authority to look outside of tribal law, typically to state law, federal law, or the law of other tribes. And depending on what the tribal rules say, there's a certain priority that I need to follow. Do I first have to look to other tribes for their law, or can I go to state law first? It just depends on what tribe I'm working for.
How does the concept of tribal sovereignty fit into the analysis you just described?
Well, tribal sovereignty means that tribes are sovereign. And what does it mean to be sovereign? Tribes are considered under the federal system sovereign nations. They have the right to make laws and be governed by the laws that they choose to make. But having said that, the tribal jurisdiction and tribal laws are limited in scope. In other words, by and large, tribal laws and tribal jurisdiction covers the tribal land, the reservation, for example, and the tribal members, whether they live on the reservation or off the reservation. But depending on the situation, the tribal jurisdiction will not cover non-members, for example. But having said that, there's a big exception. So for example, if somebody comes on, a non-member comes on to the reservation, by virtue of coming onto the reservation, they're consenting to the jurisdiction of the tribe, and by extension, the jurisdiction of the tribal court. So I see many, many cases where the other party is a non-tribal member, but I assert jurisdiction because that person came onto the reservation, for example, to, and go to the gaming institution or go to the resort or whatever it may be. So in those cases, I have jurisdiction.
So could that also extend to, let's say, a non-native spouse who resides on the reservation, who is in need of an adult guardianship?
Yes. I'm sorry. Yeah, indeed. So if you have a non-tribal member who resides on the reservation, again, they're by implication, they're consenting to the jurisdiction of the court. And in that particular situation, if there's a need for an adult guardianship, that person, whether they're tribal or non-tribal, can file a petition in tribal court asking the court to exercise jurisdiction over the potential ward. And that has happened, and I've seen that a number of times. And the court generally will assert jurisdiction. Now, it's interesting. Let's say the ward is a tribal member but does not live on the reservation. Then, depending on the judicial power that the court has, I may or may not have jurisdiction over that member who lives off the reservation. But I haven't had a situation where I've been challenged in exercising jurisdiction in that situation.
Could you talk about the interplay between tribal court jurisdiction and state court jurisdiction and how you resolve those questions?
Well, California is unique because California is what is called public law 280 state. So in a non-public law 280 state, by and large, state law has no effect in Indian country. So in non-public law 280 states, the reservation is basically a barrier to state law. But here in California and 5 other public law 280 states, Congress back in 1953 allowed those 6 states to exercise not only their criminal jurisdiction in Indian country. When I mean Indian country, I mean reservations. But public law 280 allowed states to exercise not only criminal jurisdiction in Indian country, but also, by and large, most of their civil jurisdiction, sort of laws of general applicability, civil laws of general applicability. So, but one has to remember that does not divest the tribe of its own inherent jurisdiction. So you may have a civil case, for example, a probate case, where the jurisdiction lies not only in the tribal court, but also in state court. So you may have a situation where you have concurrent jurisdiction. And those cases are common.
Could you talk about the importance of cultural competency and what trust and estate practitioners coming into tribal court need to know before they get there?
Number one, to recognize and understand that the tribal courts are legitimate courts. We function just like state court function and state federal court functions. We serve the tribal community by and large, but we are legitimate courts. Most of the courts that I work for are created by virtue of a provision in the tribe's constitution, and most of the courts I work for, if not all of them, have robust rules of court, rules of procedure. So a practitioner who's let's say experienced only in state court, if he or she were to come into tribal court, at least the tribal courts I run, they wouldn't be surprised. The court operations are similar to most Western courts. We have, as I said, rules of procedure. We have ordinances, but the cultural competence issue is a good point, because what a practitioner has to understand in tribal courts, because tribal traditions are typically divergent and different than what you'd see sort of in the Western culture, tribal traditions are really geared toward resolution, geared toward remediation, geared toward restorative justice. So if you come into tribal court, although you'll be able to litigate your case and represent your client vigorously, keep in mind that the goal of tribal courts, consistent with tribal traditions and mores and customs, is to restore the broken relationship and try to come to a mutual understanding, what's the best resolution in a given case.
You mentioned tribal law and custom, and I understand that from what you said earlier, that's something you actually look to when you're trying to resolve a particular case. How do you evaluate what a particular tribe's custom is in a matter?
Typically, that'll come through a tribal elder who is steeped in the customs and traditions of the tribe. And that person could be, someone who's lived on the reservation for all of their lives and is quite familiar with the customs. It's considered sort of an elder in the community. So I can look to that person. I also can look to academic sources as to people who have studied the traditions and customs of the tribe, because unfortunately, COVID has taken a lot of elders away from us. So there's been a big body of tribal customs and traditions that have unfortunately, passed. So making sure that the customs and traditions of the tribe are maintained is an important consideration. So we would look to an elder who can provide us some information, but I also look to the parties, and I ask the parties who they would suggest who would be a good person to advise the court of the customs and traditions, because I am not a member of the tribes I work for, so I'm not familiar with all their customs and traditions. So I have to look to a third party, if you will, to educate not only myself but the litigants in the case as well.
Do you see tribal law and custom as providing sort of a deeper interest on behalf of tribes as litigants in particular proceedings, as opposed to maybe a traditional state court proceeding where they would not be participating?
Yeah. And yes, so the tribes have a great interest, at least in my experience. And for example, let's say we have an adult guardianship case before the court. The tribes have a great interest in making sure that case, as the case evolves, the traditions and customs of the tribe are respected and upheld. For example, and I've had this situation where I've issued orders, for example, where a ward, somebody is involved in an adult guardianship, is ordered, let's say the guardian is ordered to make sure that the ward gets to cultural events, is able to engage in cultural activities, whether it's a sweat, whether it's powwow, whatever it may be. And so tribes are very, very interested in maintaining their culture and making sure that tribal members have access to that culture and promote the culture.
What types of trust and estates issues have you seen as part of your day-to-day calendar?
I've seen a variety. For example, I've seen situations where tribal members who are members of a tribe that have a robust gaming operation and per cap payments are paid. Let's say that person passes away and they have a substantial estate. I've seen that. That tribal member may have an estate plan created, and the court there may be litigation over the estate plan, so the tribal court has to hear that. I also hear a lot of estate issues when it comes to allotments of tribal lands or assignments of tribal lands. And with allotments, for example, you can have an allottee who is allotted property 40 years ago, has now passed away, and now there are dozens of heirs who have an interest in that allotment. On the other hand, you may have a situation on a reservation where a tribal member who has been given an assignment, which is essentially a right to live on a parcel, but most of the tribes I work for that have assignments, the tribal law allows the assignee to designate who should take over the assignment when that person passes. And so I have cases where I have to deal with how the assignment is going to be distributed. So those are the unique trust and estates issues that come into the tribal court. But as tribes become more economically successful, I think you're going to see more cases come to tribal court when you're dealing with large assets, if you will, a decedent who has large assets, or a potential ward who has large assets that needs a guardianship.
Have you seen elder abuse issues?
I have. Unfortunately, I have seen elder abuse issues, and I think there's an uptick in elder abuse cases. Tribal communities are no different than non-tribal communities. The same types of issues, the same type of dynamics that occur in non-tribal communities apply and occur in tribal communities. So elder abuse is ubiquitous in non-tribal communities, and it's also something I see in tribal communities as well.
How can we as trust estates practitioners use our expertise to help educate you, the judge, particularly when there's might be a complex interpretation issue or some unique jurisdictional issue involving probate property?
That's a good question, and a good question, because oftentimes I will be confronted with an issue that there is not tribal law on that particular issue. In this area, particularly when it comes to trust and estates, there's not a great deal, there's not a developed body of case law. And oftentimes there'll be an issue that's even not covered by the tribe's ordinances or codes. So practitioners need to be able to educate, I'm speaking for myself, educate me if there is a gap in tribal law as to what other jurisdictions have found and how other jurisdictions have resolved that issue. If it means going to state court and looking at the state probate code or looking at state case law, then feel free to provide that information to the court. And I think most of my colleagues would agree that we need the assistance from practitioners if there's an area that's not covered by tribal law. And depending on what the tribal codes are, I can take authority out of the authority from, for example, state court and state court case law, and use that either as persuasive authority or guidance. It just depends on what the code says. But I will often need information from other jurisdictions to help me answer a question under tribal law, because oftentimes the tribal law is silent.
Is there any other issues you think trust and estate practitioners should be aware of in coming into tribal court?
Just as I said earlier, just understand that tribal courts are legitimate courts. You would, like I said before, if you came into this courtroom where I'm sitting now, it would be just like any other court a practitioner would see. Also, keep in mind that tribal court judges are going to allow the parties to present their cases, to litigate their cases. And so don't be afraid of coming to tribal court or think that you're going to be either hometowned or you're not going to be able to present your case. But keep in mind, as I said earlier, is the whole goal and the ethos, if you will, maybe that's the best word, the ethos of tribal jurisprudence is to come to the extent that we can to a harmonious resolution of the case. That's not always the case, but that's sort of the overarching goal. So that's what I would close by recommending, keeping that in mind.
Well, thank you, Judge Wiseman. We're very appreciative of your time and expertise on this issue, and hope to have you on for a future video for additional discussion.
My pleasure. Thank you very much, and thank you for giving me the opportunity to talk about tribal courts.
Thank you to Judge Wiseman for enlightening us on tribal courts. It was fascinating to hear how the judge tries to balance the law and tribal customs. Perhaps the notion that the ethos of tribal jurisprudence is to try to come to a harmonious resolution of the case is a lesson we can all take with us. As author Susie Kasem writes, understanding languages and other cultures build bridges. It's the fastest way to bring the world closer together and to truth. Through understanding, people will be able to see their similarities before differences. Please visit ACTEC, actec.org/diversity for more information and resources on this topic, and make sure you subscribe to ACTEC's YouTube channel to be informed of new videos as they become available.